I was sexually harassed by a judge when I self-represented in a civil case. Hi, this is Mohini Prasad in the Greater Toronto and Brampton area. My mother passed away in 2019 and my brother forged her will to gain control of her estate assets with the help of his lawyer. This resulted in a tainted settlement for which I had to take him to court. His settlement would bankrupt the estate and directly conflicts with the interests of the estate. Like most Canadians, I couldn't afford to pay hundreds of thousands of dollars to get a lawyer, so I self-represented and won every case until June 17th of 2021 when my case managing judge came on to me. It was clear to me that he wanted sexual favors to do his job. Because I chose not to respond to the sexual advances of this Superior Court judge, he reversed all of his orders that were previously in my favor and severely prejudiced my application with the help of the other Toronto judges in the area. The lawyers came up with a great idea to have the judges declare me vexatious to prevent the sexual harassment from being exposed, conceal my brother's self-dealing, and hide the unethical behavior of the judges and lawyers involved. The judges made quite a sport out of continually preventing me from defining the scope of my own disclosure requests, and they allowed only the conflicted parties' lawyers to draft the orders, resulting in the lawyers granting themselves the disclosures they already had and never requested. When I appealed the orders, the judges wanted to edit the transcripts and not disclose the audio recordings. The appeal judge tried to force me to file my appeal materials without the benefit of the audios or unedited transcripts in order to set me up for an appeal doomed to fail. This would have amounted to bald allegations against the judge without the proof to substantiate it. Under these circumstances, I could not file my appeal materials, and the appeal judge labeled me vexatious. The judges used the case management of the two disclosure and conflict applications to facilitate the lawyers to employ a mix of procedural maneuvers and bald allegations to prejudice and dismiss the applications as a way of spiting me for not responding to Justice McEwen's sexual advances. When I filed a complaint with the Canadian Judicial Council, the appeal judge laughed, saying, "The CJC won't do nothing," and nothing they did. After 9 months of this, I got sick and the judges refused to accommodate me. My other brother, who filed a similar application, is disabled and has been in the hospital since early August. The judges have refused to accommodate him as well and dismissed his application. Dietrich has been abusive to me and any other self-represented sibling who took any position to stand with me. I don't believe it's her job to mandate any party's position. She's been misrepresenting events at hearings in her endorsements and the attendees as well to help make me out to be vexatious. Sexual harassment is vexatious, and this is an extreme case of it. Because I didn't respond to this judge's sexual advances on me, he punished me with the help of his judge friends by preventing me the right to disclosure and the right to have my application heard. According to a CNN report, sexual misconduct of judges is fairly rampant. The problem is the judges are judging themselves and no one is holding them accountable.